The federal appeals court ruling moments ago that the president does not have presidential immunity from grand jury investigations. The battle now may be heading to the U.S. Supreme Court. We have live Team Fox coverage. In a moment, we'll get to the Justice Department live with David Spunt there. But we begin now at the White House with our chief White House correspondent, John Roberts, on the North Lawn. John, good morning.
Bill, good morning to you. This is a case that's been going on for some time now. There was a federal district judge in New York City who ruled that the president had to hand over, at least not the president, but the president's accounting company, Mazars USA, had to hand over 8 years of tax returns to the Manhattan District Attorney Cyrus Vance Jr. The president's attorneys then appealed that to the Second Circuit Court of Appeals, which handles the jurisdiction of Manhattan. That Second Circuit has now come down with a ruling upholding the district court judge's decision that the president's accounting firm has to turn over those tax returns. In the opinion, the judges make a distinction between a criminal proceeding and a grand jury investigation, because don't forget, this was a subpoena that was issued by a grand jury that was impaneled by the Manhattan District Attorney. So the three-judge panel saying, we hold, however, that any presidential immunity from state criminal process does not extend to investigative steps like the grand jury subpoena at issue here. We accordingly affirm the district court's decision on the immunity question, which means that the president is not immune from this, which we construe as an order denying a preliminary injunction, vacate the judgment of the district court, dismissing the complaint on the ground of Younger abstention, and remand for further proceedings consistent with this opinion. Now, this does not mean that the White House and the president have lost the final battle here, because, again, this was decided by a three-judge panel, which included the chief judge and two circuit judges. So now the president has a couple of options here, Bill. His attorneys can appeal to the Second Circuit for what's called an en banc hearing, which means that all of the judges in the Second Circuit would rehear this case and decide the case, or they could take it to the Supreme Court. We're still awaiting a decision on what they're going to do about a similar ruling in the Washington, D.C. Circuit Court of Appeals. That a three-judge panel determined that the president did have to hand over his tax returns. And we don't know if they're going en banc with that or if they're going to go to the Supreme Court. So they may be gathering all of this together and take it right to the Supreme Court. I expect to hear from the president's attorney, Jay Sekulow, sometime in the next few minutes after he gets a chance to go through this rather lengthy decision. But the bottom line here, the Second Circuit Court of Appeals upholding a federal district court judge in Manhattan's opinion that the president's accounting firm, Mazars USA, has to turn over those 8 years of tax returns to the Manhattan District Attorney for investigative purposes. And we should point out, Bill, that this means that those tax returns can be used to develop investigations. They can't make them public, at least not yet. But maybe if they do develop some sort of investigative material that leads to a subpoena or an indictment, then some of that information may come out. But we're still a long way from that, Bill.
Okay, all right, news when we get it. Thank you. John Roberts running all that down for us from the North Lawn.